Li. She is the Chief Resource Officer and Acting Chief Operations Officer at PD International, an applied think tank and solutions provider located in Baltimore, Maryland. Ms. Li is testifying on behalf of the United States Women's Chamber of Commerce. The U.S. Women's Chambers of Commerce was founded in 2001 to increase economic growth opportunities for women. Welcome.
Thank you, Madam Chairwoman, Ranking Member, members of the committee. I am here today as a member of the U.S. Women's Chambers of Commerce representing our 500,000 members. Over three-quarters of our members are small business owners, many of whom are active contributors to high-tech innovations, including research and development for both the federal and commercial sectors. My firm, PD Inc., is an innovative technology firm and hubs on small business. The firm was founded in 2001 for the purpose of inventing technologies that are the first to effectively solve existing technical problems that are of significant social and economic impact. Since the year 2004, PD Inc. has devoted major resources into the R&D activities of voting technology. Our research has focused on a holistic design of new breed voting machine that would address problems existing in current voting technologies in order to accommodate all stakeholders, such as election officials, voters, and the federal government, in their needs of having a easy-to-use, easy-to-manage, accurate, fair, transparent, and verifiable election process. One of the major subcomponents of our design is an essential innovation in addressing security problems, which have been a major contributor to social controversial and the public scrutiny in the past years. At the beginning of 2008, we identified that the SBIR opportunity at the National Science Foundation could be of benefit to our specific innovation. The SBIR application process is complex in its requirements of documentation, one of which is a letter from an existing potential customer or customer to support the invention of such technology. However, our customers would generally be county and municipal election officials who, as public sector personnel, cannot endorse a product or technology marketed by a particular commercial entity. We did not have enough time to allay any endorsement-related concerns. Therefore, we decided not to file our application at that point. In the latter half of 2008, we proved that the prototype build of our product is economically viable, and there hasn't been such a device in the commercial space. At this point, we were beyond phase 1 in the R&D process, but we still need money to build it. Phase 2 of the SBIR award would solve our funding needs. However, we are not eligible to apply because we haven't gone through phase 1. If we apply for phase 1, it is not only dishonest, it also would waste precious human and monetary resources to repeat procedures that have already been done. We recommend that small enterprises which are able to secure independent validation of their technology should be allowed to bypass phase 1 and apply directly for phase 2 assistance. We support legislation that does not permit business to evade phase 1 of the SBIR program, but does allow an exception to be granted for companies that can demonstrate to agency SBIR proposal evaluators that the company has fully completed phase 1 work. For example, SBIR program participants that have already demonstrated proof of concept utilizing their own financial resources, in addition to have acquired validation through peer review conducted by recognizable subject matter experts, should be allowed to opt out of phase 1 and go directly to phase 2. This would save the innovators time and enable them to adhere to their schedule of innovation. Meanwhile, it also helps saving taxpayers' money. Other recommendations: acquisition of the services of patent attorney should be recognized by all federal agencies as eligible expenditure under both phase 1 and phase 2. Efforts should be put into place to protect small business rights to intellectual property. Regulations should bind the large industrial partners of SBIR program recipients to protect small innovators' interests in intellectual property during the process of applied research collaboration. A standard NDA agreement should be drafted by SBA, which large prime personnel would be required to sign before requesting small businesses disclose their intellectual property information. And the code of conduct should be established to regulate large prime personnel's behavior. SBA should work with SBIR recipients and perhaps with the U.S. Patent and Trade Office to assist businesses with the filing of patent applications. We strongly support the venture capital provisions detailed in the legislation under consideration, which permits SBIR awardees to receive venture capital partnership vital to linking small businesses, innovation and research to capital and market opportunities. We must make sure there are safeguards within the legislation, the regulation, and the practical application of the rules to protect small business from exploitation by larger businesses and the venture capitalists. We support maintaining majority ownership and board representation by the small firm. Thank you again for the opportunity to provide input here today. We applaud the work of this committee to energize research and innovation within the small business community and assist with the transfer of this innovation to federal government and commercial sectors. Thank you.